Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today's video is another in our series entitled Real Estate Fundamentals You Should Know. I have received so many questions lately about how to use the blank addenda space on the face of the purchase and sale agreement, Form 21, for example. Each purchase and sale agreement, the numbering system is going to be a little bit different on the face of the form. So instead of giving you a paragraph number, I'm just going to reference you, or I'm going to refer you to the blank lines that are entitled Addenda. Now, let me start by saying I don't really care how or even if you use those lines. What I care about is that when the purchase and sale agreement is all put together and you have a buyer and seller signature on the document, that the document itself is legible, understandable, and well organized. Those blank addenda lines are a tool designed to assist you in keeping a well organized document. The lines work as well as your understanding of the lines. Too many brokers have no idea how to use those lines, and so instead of the lines being a tool, they become an obstacle to organization, and they create chaos in the transaction rather than order. So let's go ahead and fill in all the blanks about how the lines were intended to be used, and really how you can use them or find a substitute for them. Okay, the idea behind the lines is that buyer-broker identifies all of the addenda that are attached to buyer's offer when buyer-broker writes an offer for buyer, buyer signs, and it gets submitted to the seller. Now, right out of the box, let's identify that Exhibit A, for example, would never be written on those blank lines because Exhibit A is already referenced and incorporated in the agreement by reference under the legal description provision up above those blank lines. So the blank lines would be where you would write, for example, Form 22A or Financing Addendum, Form 22B or Home Sale Contingency Addendum, Form 22D or Optional Clauses Addendum, etc., etc. Most buyer brokers are going to use the lines to identify all of the addenda attached to their offer. And in many cases, in fact, that information actually gets auto-populated to those lines as part of the buyer's offer. That's great. And I would encourage buyer brokers, if the information doesn't auto-populate, use the lines for that purpose. Identify all the addenda that are on those lines, and then use the tool for your benefit. Before you submit the offer to seller, do two things. Make sure all of the addenda that buyer has signed or initialed are actually referenced on those lines, and then, buyer brokers, make sure all of the addenda that are referenced on that line are actually part of the agreement that you're going to deliver to seller. I can't tell you how many times I get questions from listing brokers saying the Form 21 referenced a Form 35 inspection contingency addendum, but there was no Form 35 attached to buyer's offer. What's the meaning of that? That's a discussion for a different video, but I'm using that as an example to re-emphasize buyer brokers. Make sure that the forms identified on those blank lines are actually attached to buyer's offer before you send it to seller. Okay, now seller gets that and counters buyer's offer. Seller counters by adding, for example, a Form 36 counteroffer addendum or a Form 22 EF or both. Now then the question is, what do we do with the reference to Form 36 and Form 22 EF? The intention behind inclusion of those blank lines on the face of Form 21 is that listing broker would have seller sign the Form 36, initial the Form 22 EF, and on those blank lines write Form 36 or counteroffer addendum, Form 22 EF or evidence of funds, and send it back to buyer's broker. If buyer accepts seller's counteroffer, then buyer would sign seller's counteroffer addendum Form 36 and initial seller's Form 22 EF, evidence of funds. That's great. If that happened that way, that would be perfect. The question that would come from many brokers would be this. When listing broker added Form 36 and Form 22EF to those blank lines, did seller then have to initial that addition on Form 21? And whether seller did or did not initial that, would buyer then need to initial that? And the answer to both of those questions is no. Because remember that the blank lines are an organizational tool only for the purpose of broker creating a well-organized transaction. It's an index. It's an index of the addenda attached to the form. Writing Form 36 on those blank lines does not, in and of itself, attach Form 36 to the purchase and sale agreement. The only way Form 36 gets attached to the purchase and sale agreement is when the parties sign it. The boilerplate language at the top of the form talks about attachment. The parties sign it, it becomes attached. Same thing for Form 22EF. Every addendum in the statewide form system has boilerplate language at the top that says that this addendum is attached to and made part of that purchase and sale agreement, and then it defines the purchase and sale agreement. When the buyer and seller initial that addendum, agreeing to the terms on the addendum, they're also agreeing to that boilerplate language, and that agreement, initials on the bottom of the addendum, is what attaches the addendum to the purchase and sale agreement, not the reference or even the lack of reference on the blank lines on the face of Form 21. Many brokers do not choose to use those blank lines. Instead, they'll create an index in some other way. They'll actually create a document that's called index. And on that blank page, they will index the addenda or counteroffer forms attached to the agreement. Or they'll use a cover letter or a cover email to identify all the documents attached to the offer or to the purchase and sale agreement. I don't care what form of index you prefer to use. You do, however, need to index every transaction. You need to have an index that identifies all of the documents that are attached to the purchase and sale agreement, buyer's offer and the ultimate agreement. Why? Because you need to keep the agreement organized in your own file. When the lender gets a document, they need to be able to look at what the index says all the forms are and then make sure they have all those forms. Escrow needs to be able to do the same thing. The broker and the designated broker on the other side of the transaction need to be able to do the same thing. Everybody needs to have access to an index of the forms and then a copy of all of the forms that are part of the purchase and sale agreement. Where we run into chaos with those blank lines is in situations where brokers don't understand the purpose of those lines. Too often, brokers believe that it's essential when Form 22EF, for example, is added to those lines, even though Form 22EF has been initialed by both parties, the brokers believe that the addition of the numbers, Form 22EF, on those blank lines also has to be initialed. And if it's not, then the agreement's not binding and either party can get out prior to closing. And that is a mistake. Again, there is no reason to initial the addition of language on those blank lines. One more thing before we go. As important as it is to keep an index of forms that are attached to your purchase and sale agreement, again, if you do it on the blank lines, that's fine. If you do it on a separate page, that's fine. As important as it is to add reference to forms that get added to the agreement, it is equally important to delete reference to forms that don't stay in the agreement past mutual acceptance. For example, let's say buyer makes an offer and includes a Form 35 inspection contingency, and seller counters to eliminate the inspection contingency, and buyer accepts seller's counteroffer. We now have a binding agreement that includes fewer forms than it did when buyer made the offer. You need to cross out the reference on the face of the Form 21 to Form 35 so that when lender and escrow and any other third party that is servicing in this transaction, when they get the form, the purchase and sale agreement, they know that Form 35 is not part of this agreement. If you don't do that, I guarantee you, lender's going to be saying, where's Form 35? We need Form 35. We can't go forward without a Form 35. because it's apparently part of the agreement because the index says that it is. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.